You're welcome to this edition of Majalisah. Today, we have in the studio with us Barrister Mahmud, a lawyer of several years standing who has worked in Nigeria and outside Nigeria to help us make sense of all the things that have happened regarding the suspension, the legality or otherwise, of the suspension of Senator Natasha Akpoti Uduaghan from the Senate for 6 months. Now, the first question I would like to ask is, what sense do you make of the happenings in the National Assembly? Well, I must put you on record that there is evidence to show that parliaments around the world do suspend their members. In some cases, even in the U.S., in the case of the U.S., there are at least 21 cases where the U.S. Congress expelled some people from the Congress. So what sense do you make of what is happening in the House?
Let me establish two things. When we refer to the US and the UK, we tend to conflate issues. We tend to, at the comparative level, present apple and oranges that don't have any sense of identicalness, identicalness. Let me put it that way. True, the US operates a constitutional democracy, which invariably means that the three arms of government are subject to the Constitution. The UK presents a different kettle of fish. It's a parliamentary system which is founded on the parliamentary notion that the parliament is supreme, or the parliament is sovereign. Here, many decisions taken by the parliament in the case of the UK is not subject to judicial scrutiny. But I do know that recent jurisprudence, and scholarship around parliamentary supremacy suggests that where matters devolves or revolves around fundamental rights, courts can make inquiry or scrutiny of some decisions of the parliament. In the context of Nigeria, ours is a constitutional democracy, and if you look at Section 1, subsection 1 and 3 of the Constitution, it talks about the supremacy of the Constitution, and it talks about the illegality of acts or actions that do not sit in consonance with the provisions of the Constitution, And if you look at the division of powers as provided for in Section 4, 5, and 6 of the Constitution, more particularly Section 6, the courts lend themselves out as that arm of government that protects the Constitution itself through interpretation of the Constitution. If the National Assembly is a creation of the Constitution, by virtue of Section 47, I believe, of the Constitution, whatever acts or actions or inactions of the National Assembly, in this case, the Senate, is subject to the scrutiny of our court. Don't also forget that Section 60 of the Constitution provides that the Senate or the House of Reps of the National Assembly can establish rules for its own internal regulation. So rules that are established by both arms of the National Assembly must be subject to the Constitution. Once they are subject to the Constitution, it now devolves around the powers of our courts to inquire into the limits and delimits of these rules and standing orders. You asked a fundamental question. Aside the points I've just made, what I make of what has happened in the Senate in the past 1 week and a half. For me, what we saw on national television last week was shameful. Our National Assembly, the Senate, turned into a theater that the French dramatists would describe as the theater of the absurd. The hallowed chambers turned into a site of contest over allocation and reallocation of seats. At that level is shameful. Two, what I take of it is, as well, is the attempt by members of the Senate, through what they have expressed publicly and the acts that they have displayed in the public space, to turn our Senate more supreme than our Constitution. Why do I say this?
Where do you say that? They have a
Well,
right to make their rules, and they have made their rules that they can suspend.
Yes, the Constitution grants the Senate the right to make its own rules and regulate its own procedures. But the right to create your own rules does not exist at large. Is also subject to judicial scrutiny. Take, for example, Section 46 of the Constitution, which talks about the mode of voting in the Senate. The question a discernible observer would ask, having watched what happened in the Senate on that day, the decision to suspend Senator Natasha Akpoti Uduaghan, was it consistent with Section 46 of the Constitution? 46 talks about the mode of voting. When any question is put to determination in this, votes shall be taken on the basis of simple majority. And that section talks about the President of Senate a deciding vote. Section 46 suggests that ethics committee tabled before the Senate. The president, on the basis of Section 46, ought to have called for a division, not a voice vote. There is no way you take a voice vote and you can achieve simple majority. And I have seen videos that have gone viral. Voice vote was taken on a question 3 times. And during those 3 times, senators who were present answered no when the president required yes to the question. And when he eventually ruled, he ruled that the yes have it. This is, for me, what transpired did not sit with Section 46 of our Constitution. Like I said, a division should or ought to have been taken. Senators should have been given the opportunity to express their voting right on the question of whether Senator Natasha should be suspended or not. And a countdown of the votes should have been made. That was not done. 2, why do I think that people, through their body languages and what they have expressed, suggest that the parliament must be supreme to our constitution is this? Before the ethics committee sat, and I'm aware that some sort of committee proceedings for content has already been initiated by the lawyers to Senator Natasha. An ex parte order was served on the committee. Having received the ex parte order, the committee ought not to have sat to entertain the allegations of unruliness, that was leveled against Senator Natasha. By sitting, it does suggest that members of the Senate, and some of them have expressed it publicly, that the court has overreached itself by issuing ex parte order against the Senate. For God's sake, the Senate is a creation of Section 47. And if you look at Section 6 of our Constitution, it grants the court the power to inquire into actions or inactions of institutions created under the ground law. The ground law here is the basic law, the Constitution of the Federal Republic of Nigeria.
So you are saying that the decision of the Senate potentially could be declared null and void.
The decision, not potentially, will be declared null and void for two reasons. when the Ethics Committee sat, there was already an ex parte order against the committee. You know, the ex parte meant that the committee was barred, from entertaining, seeking to determine the subject of allegation made against Senator Natasha that was before it at the time. So the decision to suspend him was in breach of the ex parte order of a competent court. One. Two, and this is important. Once you haul somebody before an administrative body or a quasi-administrative body, in this instance, ethics committee, the rules of fair hearing ought to be adhered to by the committee. The rules of fair hearing is protected by Section 36, subsection 12 of the Constitution. Don't forget Section 36, is part of Chapter 4, which deals with fundamental rights of citizens as protected by our Constitution. The rule of audi alterem partem, was Natasha given the opportunity to defend herself. She could not have defended herself because there was already an ex parte order against the committee. But did the committee avail Natasha the opportunity of appearing before it to defend herself? I'm sure you've seen documents flying in the public space of the committee inviting Natasha to appear on a certain day, and a decision made to suspend Natasha made on a day that came much earlier than the day she was invited to appear before the ethics committee. This itself suggests that the decision of the committee was predetermined. And there's also a video in the public space of the Senate president caught on camera expressing himself and telling whoever was listening to him, take the matter to the ethics committee and let her be suspended. So for me, all of this, if brought before the court, and it surely be brought before the court, will create some exculpation, for Natasha. But my point is that the suspension of Natasha, on the basis of procedures, cannot look. In law, we talk of substantive aspect of law, and we talk about the procedures. The procedure for which Natasha was tried, does not sit with our Constitution. And I mentioned Section 46, Section 60 of the Constitution, and did not take into account the rules of natural justice. For somebody who's brought before a committee to be heard by the committee, Natasha was not heard. And there was also an abuse of procedure with what we saw on camera, what we heard the Senate president say on camera, that they should take the matter for this committee and let her be suspended.
Even though you have said that the Nigerian situation is different from other climes, if you look at the statistics that have come out, the U.S., on the average, the U.S. has not, if you look at the time frame of the Congress in the U.S. and our existence from 1999 to date, Nigerian parliament seems to be suspending more members, to be more punitive than other parliaments in the world. Why do you think it is that way?
Well, I'm not a member of the National Assembly, but as a discerning observer, I think the octane politics that our members, the senators, members of House of Reps play, in both chambers, is responsible for the high turnover of suspension of members of the two respected arms of the National Assembly. Take the Natasha team, for example. the matter would have been dealt with without allowing the incursion of our personal politics and our personal uh, uh, the personal hate, so to speak, that members have for themselves. Immediately she complained that that a seat had been reallocated and stood on the basis of Order 10, which talks about the privileges of members. A more discerning presiding officer should have allowed that on the basis of that Order 10, because the Order 10 is driven mainly by the permissive use of the word may, which means that it is not compulsory on the part of the presiding officer to rule that a member would have to speak from the seat he or she had been allocated to. So for me, for a more discerning presiding officer, understanding the high stakes, because Natasha comes from the opposition party and the presiding officer is of the ruling party. He should have been able to create some wedge against the bitterness of politics and should have allowed that to speak on the basis of Order 10. He did not. And situations right inside the chambers degenerated, to the level in which she was walked out of the chambers of the National Assembly. For a more discerning officer, official, he would have been able to look beyond whatever problems that existed between both of them and the politics of it. So for Nigeria, I think we'll have a high turnover because people who have power end up not being disciplined by power. So at every turn, they try to show who is in charge. And if you look at the names of people who have been suspended, for example, let's take the name of, I think, Aliyu, an assistant inspector general of police, who was the first person to be hammered, who said that each time he appeared before the chambers, he looks around, he sees faces of people who he investigated while in the police force, who committed serious crimes against our nation state, A more discerning National Assembly would have would have set up an ethical investigation into the allegations that he made at the time. But he was forced by power within the structure of the National Assembly, and he had to eat his own vomit. And on the basis of the apologies he made to the National Assembly, he was readmitted. But events thereafter showed that there was truth in what he said. Maurice Bekwe, who was a member of the National Assembly, died in prison of our country over 419. And
now, looking forward, I just want to know what really should we be thinking about in terms of things working effectively and properly in our discourse. Because if you look at the controversy now, Nigeria is all over the world for very bad reasons. And the statistics by UNICEF, statistics by the World Health Organization show that sexual harassment is very prevalent in sub-Saharan Africa. And the worry is that this is not about to die.
Yes, it's a great worry. I think the allegation on sexual harassment is not something that comes within the purview of the powers of the National Assembly. I've consistently made this point. Sexual harassment is a crime in our country. It's a crime in our statute books. If you look at the Violence Against Persons Act, for example, I think Section 18 or thereabout of the VAFT Act 2015, Section 285 of the Criminal Code, and Section 360 of the Penal Code, which operates in Abuja, FCT, and the 19 northern states, criminalizes any attempt, any conduct, that that is of, that is of sexual nature, that will visit on the bodies of women or of men, of men. What I expect the National Assembly to do, my expectations are one. For Natasha, who made the allegation, and she's a lawyer, she ought to have known on the basis of the authority of Sedu Gaba against University of Maiduguri that matters of significant criminal nature do not devolve within the adjudicatory powers of administrative bodies or quasi-administrative bodies. Is only institution charged with responsibility of investigating crimes, that can look into the allegation. Natasha should have reported the matter to the Nigerian Police Force on the basis of the combined provision Section 4 and 24 of the Police Act. The police would have seized the opportunity of investigating the allegation. Two, she also raised the issue of official misconduct, which I think is within the purview of powers of the ICPC. I do not think she has done that. But the police on its own and the ICPC on its own, without anybody writing petition to them, should have been able to knock on the doors of the Senate President and Senator Natasha to appear before it. One, to establish facts of the allegation she has made, and for the Senate President to enter a defense, for himself. But all of this hasn't happened. The reputation of our country is being dragged in the mud. What ordinary people would think about, and I'm sure this has occupied conversational spaces, around the world, particularly in the West, that if a sitting senator could make such damning allegation against the presiding officer of the Senate, it does also appear that sexual harassment is a social problem in Nigeria. The same way the world takes India as the capital of rape. But I think it gives us the opportunity of addressing this issue. Sexual harassment came up when the Emir of Kano, Sanusi, was the governor of Central Bank. It was swept under the carpet. The issue of sexual harassment arose against a sitting governor, I think the governor of Yobe State at the time. It was swept under carpet. You see, we are dealing with a country where patriarchy rules. And because patriarchal structures are totalizing, the tendency exists that women would live at the wrong end of the stick, provided by patriarchy. And for us to put a handle on this problem, nothing lends itself, as that example that we can make by addressing sexual harassment as a problem than the allegation that Senator Natasha has made. The Senate.
In the case of Senator Akpabio, unfortunately, this is the second time.
Unfortunately for him, this is the second time. It will be difficult for him to wash himself like that leper in the Bible who went to the pool of Bethesda, Bethesda, where, if a woman came out to say, look, you made sexual advances to me, and in resisting your advances, the woman slapped you. There was no denial at the time. There's some truth established in the public space. And these women making these allegations are not pushover women. They are women in their own rights, women of substance. For them to come to the public space and make such damning allegation suggests the furnace of thought that the furnace that they may have put their thoughts through, also suggests the courage that they are attaching to whatever they are doing. And if you look at Natasha's video when she appeared before the IPU panel at the United Nations, that she became very emotional around these issues, suggests that there's more to see that meets the eye. It's not a good thing. It's not a good thing for the Senate president, regardless of the bravado that he shows in the public space. His name, his personality, whatever he stands for, is in the mud. And invariably, the Senate of the Federal Republic
if you were
is also
to advise the Senate president, what would you tell him to do?
I will surrender myself to the police. I will surrender myself to the police. I will ask the police,
how about
investigate.
The Senate itself, because now the impression, the Senate chairman on ethics himself was debarred in the United States.
See, the Senate appeared, missed the ball. When Natasha appeared in the chambers of the Senate and challenged them and made this and reaffirmed the allegation she made in the media to the face of Mr. President, of the President of the Senate. What the President ought to have done in referring the matter to the Ethics Committee, first, she should have stepped aside to allow the Deputy Senate President to rule on whether or not Natasha could present or resubmit the petition before the chambers of the Senate. He did not. He's rankest, and not only as the Senate President, but in his capacity as Senator Godswill Akpabio. His refusal to step aside is what is rubbing mud literally in the face of the Senate. But like you asked, if I'm placed in the shoes, what will I do? The issue of crime is not within the purview of powers of the Senate. It lies elsewhere. It's in the hands of the Nigerian Police Force and the ICPC. I would surrender myself to the ICPC and the police and ask both institutions to investigate me. Before I do that, I will step aside as Senate President as the President of Senate of the Federal Republic of Nigeria.
Now, the question I want to ask is, if Akpabio just goes ahead and simply steps aside, it will give room to another person, another woman, to come and level allegation against somebody, and the person will resign. We set a bad example.
No, your question is quartered around the assumption that is a rebuttable assumption that the allegation made by Natasha is, let me look for a charitable word, may not be true. May not be true. That an allegation is made, well, at the level that we are now, it is not our duty to establish the truth or falsehood of our allegations for the police to establish that. And once the allegation has been made and Akpabio surrenders himself to the police and also steps aside, which is the most ethical thing to do in order not to rubbish the image and reputation of the institution he represents, he presides over. And in the runoff of, in the final analysis, with the police having investigated and come to the truth that there's no substance to the allegation, one, it gives some sense of exculpation to Senator Akpabio. It restores some integrity in the Senate. And three, this is more fundamental. It creates that process for which somebody who temporarily stepped aside can return to his office. That grievous allegations of this nature are made does not do not mean that from the word go that the allegations are untrue. It is for the police to establish the truth or the falsehood But in matters between man and woman, like our people say in Edo State, now wetin happen for inside bedroom, na only man and woman know wetin be the truth.
Yeah, but another issue that is coming up now is the fact that the chairman of the committee of ethics and privileges ought not have been in the Senate in the first place because of the fact that he was debarred by a competent court of law for the gross misconduct.
Yeah, when he sat over the case against Natasha, the facts that we know today were not in the public space, as far as I'm aware. But the facts that are now in the public space make his position as chairman of the ethics committee untenable. I've heard some lawyers, and they have expressed themselves in some of the platforms, of lawyers that I belong to, that he was debarred in the U.S. has no relationship with what happened in the chambers of the National Assembly. As beautiful as, as spurious as that assertion appear, my view is this. Abuse of ethical rules, no matter the nature of the abuses, are what they are, abuses. That a man who could not stay in fidelity to the rules of practice, in New York, from the allegations that are already in the public space, who voted away with cleansed money, abusing the ethical rules of practice elsewhere, now sitting in an ethical committee, in the highest lawmaking body of our country, does not speak well of that lawmaking body and does not speak well of our country. If I were
let me ask a
Senator,
question. Let me ask a question. Was he debarred as a result of a court judgment, or he was disbarred by the association? Was the disbarment not as a result of the court finding out that he had committed what amounts to a crime?
There were debarment proceedings against them. I've seen written
civil matter or a criminal matter.
There's no distinction between civil and criminal. It's an abuse of ethical legal practice. Cleansed monies were in his possession, which he did not use for the purpose for which the monies were sent. They were sent to him. I've seen communications that were sent by the court in the U.S. Inviting him to enter an appearance and make a defense. He chose not to enter a defense. Invariably in law, when you don't enter a defense against allegations made against your person, the assumption in law, a rebuttable assumption, is that the allegations are true. They're true. He bolted out of the U.S. and returned to Nigeria. And I'm very sure that this senator may have, since 2009, committed perjury in our country. Because as a lawyer, there are forms you fill in the course of your work. When you are asked, have you had any issue regarding ethics in the course of your practice? I'm sure he must have encountered this, and I'm sure he must have answered no. So if we dig further, issues of perjury and the likes, can be made against. But on the basis of ethical practice, fidelity to ethics, you cannot be sitting in a committee that tries people for abuse of ethical rules of the Senate, and you yourself is an abuser of ethics to the extent that the profession you belong to, you were debarred, albeit elsewhere. And
So,
as people say that, it didn't happen in Nigeria. The proceedings of that, the debarment proceedings can be brought before the disciplinary committee of the MPA, and some actions can be taken against him.
so where do we go from here in terms of our institutions? If you could get away with all those things, it means that the institutions that do the vetting are so weak they are unable to perform their duties.
Absolutely. Our institutions are weak, and appointees, people who are appointed to administer or run these institutions are weak to the extent that they hardly do what's expected of them. Look, today in our country, technology has made uh, fact finding, very simple, very simple. You can sit in the bedroom of your house, tap my full names on uh, on on a search engine. Has Abdul Mahmud ever been arrested and tried for crime? And see what will pop up. I know that there are uh, criminal record platforms on the internet. All you need to do is pay a few pounds in the UK, for example, and apply to have criminal record of Rima Shawulu, If you have ever had any reason to have been hauled before the police or before a court in the UK, whether criminal or civil or county court, in the UK, the records are there. But our public institutions are not doing what is expected of them. Huge monies that are voted for them each year in our national budget. We ask ourselves, what do they do with these monies? And that's why uh, a man who was debarred in the US in 2009, uh, could return to Nigeria, make no formal disclosure, and he sits in the highest lawmaking body of our country. And in the midst of the cacophonous voices that have emerged around the issue of ethics, we have not had the MPA, uh, who is the regulator of ethics. We have not had the disciplinary council of the bar, who is also the regulator of ethical practices within the profession in Nigeria. And look, it tells you that we are not serious in our country. One day, somebody who made a foreign country blind, will end up as governor of Central Bank of our country. If we have not even appointed thieves as governors of Central Bank of our country. And in a broader context, as our people say, when the head of a fish, when the head of fish they rotten, the body itself go they rotten. We are talking of a president of our country who has drug issues hanging around his neck. We imagine the president of our country. So what stops our honorary citizen who is a criminal from becoming a senator or a member of the House of Representatives of our country? We have a president whose records, school records, are dubious, that we do not know the institutions he attended, who is today the president of our country. And you see, look, like I said, when fish head rotting, the body itself will be rotting, and that's what we are dealing with.
Thank you very much, Barrister Mahmoud. It's a pleasure having you for this conversation. We'll be talking more and more. This is Majalisah, our platform for open discussions. Your views, you are right. Thank you very much. You're welcome.
Right, thank you, sir. It's been my pleasure.